Welcome back to Cracking the Code 3rd edition. Now we're in the glossary and we're on R's. Here we go. Ransom, Hebrew, kofar. The compensation required to avoid bodily punishment or to free oneself from an undesirable state or condition. Isaiah 43 verse 3. The term kofar is related to the Akkadian kaperu, to wipe off, or kupuru, to expiate. The substitution for a penal sum or corporal punishment was widespread in the ancient world. Thus, the Hittite code provides for fixed damages for bodily harm, and the Bedouin too allowed for ransom as an alternative to blood vengeance, except in the case of murder, as seen in Numbers 35 verse 31 through 34. The Israelites followed this practice too, though fixed sums do not seem to have existed in early times. Instead, the principle of measure for measure was employed, Exodus 21:36, Leviticus 24:18, together with the specific standard for determining the compensation, Exodus 21:19 and Exodus 22:16. Later, set amounts were established in Deuteronomy 22:29, such as the redemption fees for those consecrated to Yahweh or Jehovah in Leviticus 27. To be distinguished from kofar in the sense of ransom, which is paid to an aggrieved party, is kofar in the sense of bribe, which is paid to a judge in hope of influencing his decision, 1 Samuel 12:3 and Amos 5:12. See also captives, ransoming of, Encyclopedia Judaica, 1972. Compare redemption. Real party and interest. The person who will be entitled to benefits of the court action if successful, one who is actually and substantially interested in the subject matter, as opposed to one who has only a nominal, formal, or technical interest in or connection with it. Barron's third. See real party of interest. Real party of interest, see note. Note, this term is not defined in law dictionaries, just as Federal Reserve notes is not defined. Big Brother's operation cannot withstand the light of day, and so must remain in the shadows. The real party or parties of interest are unknown. A real party in interest, defined directly above, is merely an intermediate link in the chain. The actual boss is the real party of interest. Rebuttal presumption. An ordinary presumption which must, as a matter of law, be made once certain facts have been proved, and which is thus said to establish a prima facie conclusion. It may be rebutted or overcome through the introduction of contrary evidence, but if it is not, it becomes conclusive. After rebutting evidence is introduced under prevailing doctrine, the competing facts are weighed on their own merits, without further reference to the presumption. Barron's third. See also disputable presumption, presumption, and legal fiction. Record. Record, except as used in for record or of record, record of legal title, and record owner, means information that is inscribed on a tangible medium or which is stored in an electronic or other medium and is retrievable in perceivable form. UCC 9-102A 69. Redeem. Latin, redimere. Buyback. To buy. Variant of emere, to purchase. To buy back. To free property or article from mortgage or pledge by paying the debt for which it stood as security. To repurchase in a literal sense, as to redeem one's land from a tax sale. It implies the existence of a debt and means to rid property of that encumbrance. Black sixth. Redemption. Salvation from the states or circumstances that destroy the value of human existence or human existence itself. The word redeemer and its related terms redeem and redemption appear in the Bible over some 130 times and are derived from two Hebrew roots, theta and gal. Though used to describe divine activity as well, they arose in ordinary human affairs, and it is in this context in which they must first be understood. PDH, let's say padaha, is the more general of the two, which cognates of related meaning in Akkadian, Arabic, and Ethiopic. It belongs to the domain of commercial law and refers to the payment of an equivalent for what is released or secured. The verb padaha, unlike gal, indicates nothing but the relation of the agent to the object of redemption, which in the Bible is always a person or living being. Its usage does not differ in cultic activity from that of a normal commercial transaction. In both cases, a person or an animal is released in return for money or an acceptable replacement. Let's see. Exodus 13:13, 34:20, Leviticus 27:27, 1 Samuel 14:45, with Exodus 21. So cross-reference these. Exodus 21, 7 through 8, Leviticus 19:20, Job 6:23. Gal is more restricted in usage and does not appear to have cognates in other Semitic languages. It is connected with family law and reflects an Israelite conception of the importance of preserving the solidarity of the clan. The Goel Redeemer is the next of kin who acts to maintain the vitality of his extended family group by preventing any breaches from occurring in it. Thus he acquires the alienated property of his kinsmen, Leviticus 25:25, or purchases it when it is in danger of being lost to a stranger, cross-reference Jeremiah 32:6 FF. When the Bible uses both pada and gal for redemption, the Talmud implies pada to ransom, see ransom, and gal to redemption. Encyclopedia Judaica, 1972. See note, compare ransom, see payment. Cognate, a person or thing related in origin. Note, per Encyclopedia Judaica, the subject of redemption belongs in the domain of commercial law, has to do with the payment of an equivalent for what is released or secured, is essentially commercial in nature, even if cultic, religious, and sacred, and wherein a person or an animal is released in return for money or an acceptable substitute. Register, to rule, rex, king. Register, to record formally and exactly, to enroll, to enter precisely in a list or the like. Black sixth, see note, reify. Note, from the Latin regere, to rule, and rex, king. Essentially, to register is to kingify, or to rulerify, oneself or one's property, that is to say, submit and place oneself or one's property in the position to be subjected, owned, controlled, or regulated, thus facilitating taxation. And it came to pass in those days that there went out a decree from Caesar Augustus that all the world should be taxed. Luke 2:1, Holy Bible, King James Version. Registration is the necessary step before taxation. Registered, denoting cattle, horses, dogs, etc., having pedigrees verified and filed by authorized associations of breeders. Webster's. Rife, a robbery. Cowl, Blacksforth. See reification, rifi. Reification, the embodiment of a right to the payment of money in an instrument so that transfer of the instrument transfers also the right. The term can also refer generally to the embodiment of any other property in a writing, which writing represents the property. Black 6, C note. Note, what was once known as simple highway robbery, a reif, is now known as reification, or the registration of the property. In the juristic trade name of your strawman, of course, consulting the words reif and reify, one can see that government has given itself license to overtly rob and steal from its subjects, or trade names, under the euphemism reification, another term for registration, per UCC 9-302. Registration constitutes surrender of legal title to the property registered, an act which precludes the necessity for the registrar agent for the secured party government to file a UCC financing statement against the registrant or debtor to perfect the security interest in the property. Latin re-thing, reify, transitive verb. To convert into or regard as a concrete thing, to reify an abstract concept. Note, this term is essentially identical in concept with the word register, literally translated means to kingify or rulerify oneself or one's property. The abstract concept that someone else can claim your body, labor, property, and wealth is converted into a reality when you or your property are or is registered, a phenomenon known as a reif or robbery. The fact of registration obviates the need for the registrar to file a financing statement against the registrant or debtor in reference to the property in question. Remedy. Remedy means a remedial right to which an aggrieved party is entitled with or without resort to a tribunal. UCC 1-201-34. Remedy is the means by which the violation of a right is preserved, redressed, or compensated. Blacks first. New. The purpose is to make it clear that both remedy and rights as defined include those remedial rights of self-help, which are among the most important bodies of rights under this Act, remedial rights being those which an aggrieved party can resort on its own motion. UCC 1-201-34. Compare rights. See excerpts from speech by Theodore Roosevelt at the beginning of this book, Corporation Soul. Remitter. Remitter means a person who purchases an instrument from its issuer if the instrument is payable to an identified person other than the purchaser. UCC 3-103-11. Res. That's from Latin. In the civil law, a thing, an object. As a term of the law, this word has a very wide and extensive signification, including not only things which are objects of property, but also such as are not capable of individual ownership, and in Old English law it is said to have a general import, comprehending both corporal and incorporeal things of whatever kind, nature, or species. By res, according to the modern civilians, is meant everything that may form an object of rights, in opposition to persona, which is regarded as a subject of rights. Res, therefore, in its general meaning, comprises actions of all kind, while in its restricted sense it comprehends every object of right except actions. This has reference to the fundamental division of the institutes that all law relates either to persons, to things, or to actions. In modern usage, the term is particularly applied to an object, subject matter, or status, considered as the defendant in an action, or as an object against which directly proceeding are taken. Thus, in a prize case, the captured vessel is the res, the thing. The proceedings of this character are said to be in rem. See in personam, in rem. Res may also denote the action or proceeding, as when a cause, when not between adversary parties, is entitled in res. Blacks first. See note in personam, in rem. Prize law. The system of laws and rules applicable to the capture of prize at sea, its condemnation, rights of the captors, distribution of the proceeds, etc. Blacks first. Prize in admiralty law. A vessel or cargo belonging to one of two belligerent powers, apprehended or forcibly captured at sea by a war vessel or privateer of the other belligerent, and claimed as enemy's property, and therefore liable to appropriation and condemnation under the laws of war. Blacks first. Compare booty. See Vice Admiralty Courts. Note, your straw man is a vessel under Admiralty law and also a prize in war. War was officially declared against American citizens by U.S. government under Franklin D. Roosevelt in the Amendatory Act of March 9, 1933, also known as Emergency Banking Relief Act, to the Trading with the Enemy Act of October 6, 1917. Prize on land is called booty. Res judicata, a matter adjudged, a thing judicially acted upon or decided, a thing of or matter settled by judgment. Blacks first. Residence, the act or fact of living or regularly staying at or in some place for the discharge of a debt or the enjoyment of a benefit. Merriam-Webster's Online Dictionary, 2002. Resources, money or any other property that can be converted to meet needs, means of raising money or supplies, capabilities of raising wealth or to supply necessary wants. Available means or capabilities of any kind. Black 6, see note. Note, the government looks upon Department of Health and Human Resources as just that. Retail, to sell by small parcels and not in gross. To sell in small quantities. Blacks first. Compare wholesale. Revenue, as applied to the income of a government, this is a broad and general term, including all public monies which the state collects and receives from whatever source and in whatever manner. Blacks first, see note. Note, government income or revenue is a revenue of funds from the private venue into the public venue. Revenue agent, any duly authorized Commonwealth Internal Revenue agent of the Department of the Treasury of Puerto Rico. See 27 CFR section 250.11. See note below. Note: the above is the only definition of revenue agent in all the Code of Federal Regulations, and elsewhere, Puerto Rico is a commonwealth. The IRS is ensconced in a private trust, Puerto Rico Trust number 62, that operates out of Puerto Rico, and a revenue agent is an unregistered foreign agent operating on the American soil in violation of the Foreign Agents Registration Act of 1938. Secretary of the Treasury is an abbreviation of the actual title, Secretary of the Treasury of Puerto Rico. Revised Article 9. Revised Article 9 governs any transaction that creates a security interest in personal property or fixtures by contract, consignments, agricultural liens, sales of accounts, chattel paper, payment intangibles, promissory notes, and other UCC security interest. See Section 9-109. William C. Smith, American Bar Association. Journal, August 2001, page 53. Rights. Rights include remedies. UCC 1-201-36. As a noun and taken in the concrete sense, a right signifies a power, privilege, faculty, or demand inherent in one's person and incident upon another. Rights are defined generally as powers of free action, and the primal rights pertaining to men are undoubtedly enjoyed by human beings purely as such, being grounded in personality and existing antecedently in their recognition by positive law. But leaving the abstract moral sphere and giving to the term a juristic content, a right is well defined as a capacity residing in one man of controlling, with the assent and assistance of the state, the actions of another. Black's first. Compare remedy. Note: rights can only descend upon one in a corporate capacity and are inextricably linked with remedy. The concept of a remedy, the alter ego of a right, immediately involves corporate entities and officers with the aggrieved party accessing his rights. Autonomous, sovereign beings neither have nor need rights, and a true sovereign neither relies on, nor draws from, nor hopes for the slightest shred of a right. Rather, a sovereign governs him or herself without intervention of any party other than God, and exercises the power that inheres within him or her without compunction. See Corporate Soul, quote from Theodore Roosevelt on Sovereigns at the beginning of this book. Roman civil law, see note. Note: there are fundamentally only two kinds of law in human society: real law, of which original English common law, as well as commercial law, are particular cultural styles and developments, and Roman civil law. The latter is a perversion of the former. Common law and commercial law, as expression of real law pertaining to free, sovereign people, are independent of organized government. In common law, for instance, a king cannot access, without permission, the meanest commoner's hovel, which is the source of the phrase, "a man's home is his castle." Roman civil law is the law of government rulers, kings, princes, emperors, dictators, etc. Over the centuries, governments have usurped the form, trappings, and genius of common law and commercial law, transmuting them into forms of Roman civil law as tools of rulership. The spirit of truth, fairness, and justice of real law have been stifled and distorted from their just intent into means to implement tyranny. The principles of both real law and Roman civil law are simple. Real law is expression of two fundamental precepts. Number one, every man has free will and is therefore sovereign over himself and his own domain. A man is fully entitled to do whatever he wishes with his life except transgress against the similar inherent rights of others. A man who damages another loses his sovereignty proportionate with that which is necessary to provide rectitude and recompense for the one wronged. In short, thou shalt not transgress against the rights of thy neighbor. All social intercourse, both express, written bilateral, and implied, unwritten, ratified by acts, not signature, is contract. Therefore, whatever contracts you enter into, you are obligated to fulfill. Roman civil law has but one principle. The will of the ruler has the force and effect of law. All human governments are necessarily some form of Roman civil law because no basis in real law can exist for any ruler to rule, that is to say, to usurp and force by force the rights of options or property of another man. Also, the fact that all life is contract is the source of the timeless maxim of law. Contract makes the law. This maxim is found in virtually every culture, language, and legal system in the world. All law, both expressed and implied, is inherently contract. An express contract is formalized in writing, specifying the various rights and duties of the parties and all the terms and conditions upon which the parties agree, with the voluntary consent of each party indicated by his signature. An implied contract is ratified by act instead of signature. An implied contract is formed, for instance, when one goes into a restaurant and orders a meal. Although no written contract is signed, a contract is formed nonetheless by the act of ordering and consuming the meal, on the basis of which one non-verbally consents to pay for it. Roman civil law functions chiefly by implied contract, ratified by the presumed implied assent of the ruled through 1. Omitting to assert and preserve their own rights and freedom vis-a-vis the ruler. 2. Accepting benefits that the government offers, thereby incurring whatever obligations are contractually implied by the acceptance. The creditors of the bankrupt U.S. government operate against you via the presumption that they hold legal title of the property registered on the birth document or certificate, and thereafter the mirror image trade name, and that it is an open-ended lien against your rights, property, and labor as security to pay on the national debt. Redemption of the birth certificate and trade name eliminates all other claims concerning each. And we will stop there with the R's, and next time we will begin with the S's. Thanks for listening.